Today in America, the stop and frisk, or the Terry stop, is used in law enforcement every day. Whether it's getting pulled over by an officer while driving your car or getting frisked in broad daylight on a busy street. The transition from before the Terry versus Ohio case to after has psychologically, culturally, and socially affected the effects of law enforcement on its suspects and how law enforcement is viewed as a whole. The main issue of the Terry versus Ohio case is whether the guidelines and restrictions given violate the possible suspect's right given to them by the Fourth Amendment. In this documentary, we will discuss what the Fourth Amendment entails regarding law enforcement, how the Exclusionary Act has affected the Terry versus Ohio case, and the rights of the officers and possible suspects during those situations. Martin McFadden, a detective in Cleveland, was patrolling downtown in normal clothes when he noticed two men, Terry and Chilton. The two men kept walking back and forth around 9 times, says McFadden, in front of a jewelry store, stopping each time to look inside. At the end of each pass-by, they would stop at the corner to confer, where a third man was also seen, Carl Katz. He was only seen on one of the rounds past the store. McFadden approached the men, assuming they were casing the joint or planning a possible robbery entry, approached them and asked for their ID, stating that he was a police officer. The 3 men mumbled and didn't give the answers that McFadden was looking for, saying things like, "For what?" and "Why would you need that?" This behavior caused McFadden to grab Terry, spin him against the wall, and pat him down. He claims he felt what seemed to be a gun and asked the men to come inside the store that they were pacing around. The pat-down was only of Terry's outer garments, where he found a revolver and found another gun in one of the other men's jackets. They were then both charged for carrying a concealed weapon. The main issue of the Terry versus Ohio court case is whether a search for weapons without probable cause for arrest is an unreasonable search under the Fourth Amendment. During the occurrence of the case, the law stated that an officer may perform a search for weapons without a warrant, even without probable cause, when the officer reasonably believes that the person may be armed and dangerous. One major thing that changed is the issue of the exclusionary rule. Under the Fourth Amendment, if the police officer gathers evidence, it's in violation of the Fourth Amendment, and that evidence can be excluded in the court, and the prosecution cannot use it against you to move forward with criminal charges. But in the case of Terry versus Ohio, the Supreme Court said that the exclusionary rule has its own limitations. And by making this claim, they've whittled away another piece of the Fourth Amendment. This was a turning point in the United States law enforcement because the Fourth Amendment, made in 1781, was very specifically articulated, and after this case, parts of it, or limitations, were created, thus giving law enforcement the attention and the majority of the power, putting individual rights not as top priority. A major cultural problem was in place during the Terry versus Ohio incident and trials: segregation. The 1960s began a blossoming insurgence of civil rights, which also meant a growing anti-desegregation group. The Ku Klux Klan not only didn't believe that the colored people shouldn't have all these new rights that they were fighting for, but they were physically going after them, killing many. Racism was not only present in the Ku Klux Klan and citizens, but even police in uniform on the job. Police brutality and unfairness took place extremely often, even now, and this relays back to the political social perspective issue of the police having more power in law enforcement rather than the individuals themselves. Police not necessarily needing to have probable cause gave some of them an excuse to hassle African Americans. The psychological factors that went into play revolved around law enforcement's control over the possible suspect. Before the Terry versus Ohio case, people weren't as informed about their own rights and what the police are and aren't allowed to do in those situations. This caused pressure and created tension between the two people. The possible suspect didn't feel safe and didn't feel comfortable when the officers came up to them out of nowhere without probable cause or a warrant of any sorts, and the officers were not obligated to tell them why. But after the case, those issues lessened because the possible suspects became aware of their rights and what could and could not be done to them, making the atmosphere of the situation better. The long-term outcomes that we still see today are almost everything surrounding modern-day stop and frisks and interrogations. They are now referred to as Terry stops and still use the same boundaries and rules as deemed in the court case. The Terry v. Ohio case was recent, 40 years ago, and the laws surrounding the Fourth Amendment protection of rights has not differed much since, regarding law enforcement. Now, even without arresting a person, the police may stop the person to ask questions. This is, of course, only allowed upon seeing suspicious activity. Under these circumstances, the police may perform a Terry stop. To ensure their own safety, the police may also perform a pat-down with the back of their hand or a weapons frisk on the outer garments of the person's clothes. During this search, if the police believe they feel something that they reasonably believe may be a weapon, they may remove the item from the suspect's clothing for further examination. However, if the police seem to observe items from a person's pockets or inner garments that seem to be contraband, they are not entitled to remove them. For questioning, without making the arrest, they can temporarily detain the suspect to request that they identify themselves and answer questions asked by the police regarding their suspicious activity. But Terry stops are limited to investigation of only that specific suspicious activity. These days, stop and frisks aren't made into a big deal, and the majority of people are content with going along with them, not arguing, or trying to get their way out of it. This is because the rules of Terry stops are reasonable now, or more reasonable. Yes, they still have altered the guidelines of the Fourth Amendment, but they still give individual freedom to the possible suspect while still allowing law enforcement to act on suspicions. The case of Terry v. Ohio greatly changed the way that officers present and approach possible suspects or people acting in a suspicious manner. The case has also clearly defined what rights the officers have, while also informing the civilians of theirs. This has created little to no confusion and tension and has prevented violent and violating intrusions of privacy when the possible suspect might not have done anything wrong. It restricted the powers of law enforcement regarding Terry stops to only be specific about the possible danger of the suspect and the fact that they might be armed. But officers can't point out any other unrelated items on the people or any other suspicions, giving the suspect more freedom than previously. Also, with questioning, the officers are required to say why they are detaining the possible suspect, letting them be aware of their suspicious activity, and letting them answer questions about it. The Terry v. Ohio case overall made the guidelines and rights a lot clearer for both sides of incidents and gave more freedom to both sides.